Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.
Equipment. First item is apologies. We've had an apology from Danny Kennedy, Paul Frew and Sean Lynch. Any other apologies? I have a feeling Sammy Douglas may be out of the country too, but if he turns up then I'll be proven wrong, but I'll put an apology in for him anyhow. Agenda item 2 then, draft minutes of the meeting for the 10th of December. If members want to look at page 5 through to 11 of their folders. If everyone's happy enough, I'll sign off in the minutes. Everyone happy? Great. Thank you very much. Agenda item 3 then, matters arising. Item 1 is a copy of the Safeguarding Board for Northern Ireland schematic review into child sexual exploitation. Members will recall the meeting on the 10th of December. We considered a correspondence from the Minister advising of the publication later that day of the review commissioned by the Health Minister in September 2013. The review was conducted by the Safeguarding Board in conjunction with Queen's University and contains one overarching recommendation regarding the thematic audit in 12 months' time and a number of broader cross-departmental areas for improvement. The report raised a number of issues in relation to the PSNI, and a copy of that report has been provided at page 13 through to 102 of your meeting folders. If members are content, we'll send a copy of that report to the Policing Board and ask them to consider the issues that are raised in relation to the PSNI. Enough. Item 2 then is correspondence from the Bar. The Bar Council has written regarding the present situation in relation to the criminal defence representation in the Crown Courts, backlog of cases and the lack of meaningful engagement, as they say, with the Department. The correspondence and associated papers are on page 103 of the folders. The Bar Council has lodged an appeal against the Judicial Review ruling and has unanimously decided to proceed with their present action and suspend discussions with the Department pending the outcome of the appeal or realistic solutions from the Minister. The Chairman of the Bar Council has indicated they welcome the assistance of the Committee and are willing to discuss the issues. I think there's very little we can really do at this point. There's proceedings that are ongoing. It's disappointing maybe the dialogue has stopped between the two parties, but if members are happy enough, we'll just note at this stage and maybe seek
Could I just ask, at any stage have you met with the Chair of the Bar to appraise yourself of the situation?
I have a few times prior to Christmas.
Right, yes.
What we might want to do again in future months is get an update in terms of the backlog, because it will have a significant impact in the next year, and there'll be a big double hit on legal aid costs as well, so it's something we want to keep an eye on. Item 3 then is the Forward Work Programme for January 2016, page 126 of the folders, and that's just really for noting. Agenda item 4 then is the Department monitoring round and budget for 2016-17. Officials will attend to outline the Justice budget for 16-17 and January monitoring round. Members will find the relevant papers at page 136 through to 193 of their folders. And there's a revised set of PowerPoint slides containing additional information on indicative budgets and resource by spending area, and those can be found at pages 3 to 16 of your table papers, which you should find in front of you. So can I welcome Glenn Capper, Lisa Rocks and Patrick Barr. If you want to, Glenn's kicking off, you want to give us a brief summary and then we'll open up the questions if there are.
Certainly. Good afternoon, and thank you for the opportunity to give you an update on the Department's finances. Looking firstly then at the 2016-17 budget. As the Committee will be aware, the timescales for completing the 16-17 budget process were extremely tight, so this is the first opportunity we have had to share any specific information. You will hopefully have received an updated slide pack which outlines the key budget outcomes for the Department, and I plan to pick some of the main points from this during your briefing. As you know, we did some scenario planning in advance of the formal budget process, and we have also provided details of the impact of 5% cuts by spending area captured as part of this exercise. However, it's worth noting that not all of this is now relevant given the actual level of cuts. Following the Executive's agreement of the 16-17 budget on the 17th of December, the Department has been considering how the DOJ budget will be allocated across the core department, our agencies and NDPBs. Indicative budgets were issued to all spending areas on Tuesday of this week, and officials and the Minister briefed all of the Department's accounting officers yesterday. Following today's session and then the Assembly's consideration of the budget, we plan to issue final budget spending areas by the end of January. Slide 4 of your pack outlines the key features of the resource budget for the Department of Justice. In summary, these are: the reduction to the police budget has been limited to 2%, or 13.8 million. The reduction to the remainder of the department's budget is 5.7%, or 19.1 million, and £15 million has also been provided for legal aid pressures. Separate to baseline funding, as you'll see at slide 5, the department also received funding from the Public Sector Transformation Fund for some voluntary exit schemes next year. This includes £12 million for PSNI and a total of £400,000 for 3 other bodies. Slide 6 in your pack shows the Fresh Start Agreement funding elements included in the 16-17 budget that are relevant to the DOJ. This includes £32 million of additional security funding for the PSNI. 2 further amounts will be held centrally, and the department will bid when the strategies to access this funding have been agreed. And these are £10 million for tackling paramilitary activity and £12 million for a shared future. There's also funding of £30 million for bodies to deal with the past. Again, this will be held centrally until agreement is reached on how this issue is to be addressed. This will be particularly important for the DOJ, as the legacy-related costs facing the department, and that includes related litigation costs, continue to grow and cannot be met from baseline funding. Slides 7 and 8 in your pack provide further detail and analysis of the department's overall budget settlement. So in considering how the funding envelope will be allocated across spending areas, the Justice Minister's priorities are as follows: protecting frontline policing as far as possible and ensuring PSNI has adequate security funding; protecting other frontline areas across the department as far as possible with the aim of protecting outcomes for the public; and then protecting the voluntary and community sector and policing and community safety partnerships as far as possible. These priorities are reflected in the indicative budgets that we have issued, summarised at slide 9, with details at slide 10. And as you can see, this includes protection of the prison service, Youth Justice Agency and Probation Board budgets to 2.9% reductions, protection of other policing bodies to 2% reductions. This includes the Policing Board, the Police Ombudsman, the Police Rehabilitation and Retraining Trust, and the RUC George Cross Foundation. Protection of the voluntary and community sector to 1.5% reductions, and protection of policing and community safety partnerships to 2% reductions. To help fund this, the core department is taking a cut to baseline spend of 7.4%. So looking then at capital, slide 12 of your pack outlines the key features of the capital budget for the DOJ. In summary, these are a total capital allocation of £58 million, and as part of the budget, the Executive has agreed to identify a number of flagship projects where funding will be agreed now for future periods. This includes funding for Desert Crete, and 3.9 million of the 58 million relates to this project. Separately, £1.5 million from a change fund will be held centrally for allocation to the Strategic Investment Board's Asset Management Unit. This will be an enabling fund for estate rationalisation, and we hope that we will receive some funding from this to support our headquarters accommodation project. Although our capital budget will be higher than last year, the total capital requests from spending areas were £102 million. So as with previous years, a significant amount of reprioritisation and rephasing of projects will be required. Indicative capital allocations are outlined at slide 14. As you can see, the largest elements of capital funding will go to the prison service, largely to support estate redevelopment and the PSNI. We also plan to not allocate £3.9 million of our capital budget at this stage. Instead, we will allow spending areas to revisit and update their capital plans with a view to allocating this funding as part of the June monitoring round. So those are the main points in relation to next year's budget, and before taking any questions, if I may, I'll touch briefly on this year's January monitoring round. As you can see from the information provided in advance, we have one main pressure of £5.9 million. This relates to the transfer of Youth Justice Agency staff from the Nilgos pension scheme to the Principal Civil Service scheme. This move crystallises the deficit on the scheme, and based on the last valuation, we intend to pay this amount in year. Our two main savings are from Legal Services Agency, where the legal profession coming off record has led to a continued reduction in the number of cases falling due for payment this year, particularly in the Crown Court, resulting in a £4 million easement. And the PSNI also have savings totalling £3.6 million across a range of areas. Netted off against the pressure, we have offered £3.7 million to DFP as a reduced requirement. So therefore, after a difficult year for financial planning with significant uncertainty over the level of budget cuts, we are on track to have a balanced budget for 2015-16. I hope that provides you with an overview of both our in-year financial position and next year's budget, and of course we're happy to take any questions you have.
Okay, thank you very much. Just a couple of questions. In terms of victim support, I can't see the information, that maybe I've missed it. What reduction are they having in funding?
Victim support would be grant supported through the department, and as Goodness said as part of his opening remarks, I think we've protected all grants to 1.5%, so then that will be passed on to victim support.
And in terms of the probation board, I mean, they had told us that if the 5% had been realised, there would have been real difficulties and they wouldn't be able to deliver a safe service. They're now 2.9% cut. What impact is anticipated in terms of the work of the probation board with that cut?
We've asked all of our spending areas, following issuing the indicative budgets, to quantify what, for probation board, what 2.9% will specifically mean. So you're right, 5.9%. They had particular issues as part of the Minister's priorities. The protection to 2.9% should mitigate an awful lot of those issues, and we'll know the exact detail when that information comes back.
And then there's a budget reduction of 2% for the RUC George Cross Foundation. Will that mean that they have to stop their bursary scheme, or will they still be able to continue with that?
As I understand it, it would mean that they wouldn't have to stop the scheme, but I suppose, like the probation board, will have to wait for the final outworkings of it, but based on the scenario planning, we wouldn't envisage so. No.
Okay. Members, any other?
Yeah. In the first part of our briefing document, there's the scenarios are excuse me, are laid out for the 5 and 10 cuts. Will you be coming back with an update from all the agencies now that they've been given their allocation?
If the committee wishes, as I say, we're capturing now what the specific budget would mean for each area.
Because
so we'll be able to share that with the committee.
Yeah, because when you read some of them, you know, like the prison service are obviously saying that if it had been 5%, then the prisoners out of time, rehabilitation, etc., will take a bit of an impact. You know, so I'm just wondering now with the new allocation what their view would be, so that we can, if you like, monitor that going forward. That would be one there. It's the same with obviously the policing. It just gives us an idea of what they were predicting, and now their reallocation, how they view it would be of value. Just in terms of the probation board, their proposed reduction is 2.9. Is that the total cut that they will get?
Yes, total cut 2.9%.
And in relation to the relationship that probation has, say, with the prison service, where there's a service level agreement, that won't have any reduction?
As part of the process now of sitting down and working out what 2.9% means for probation board and prison service, there'll no doubt be a dialogue between those two bodies. So it's too early for me to say what, if any, there'll be an impact from prisons on probation. But what I can say at the minute is that both bodies have been protected to 2.9% to try and mitigate the impact on both organisations. But too early to say if there's any cross impact between the two.
And in terms of that relationship, you know, what role does the department play? Is the department now out of it, and it's between the prison service and probation, or does the department, you know, when they're given the allocation, say to the prison service, say, you know, be mindful of the impact that not having a probation service running at a certain level, that they don't interfere with that service level agreement.
I suppose where the department has played a role is that in asking all areas what the impact of 5 and 10% cuts would have been, we were able to see what those actual impacts were.
Yeah.
So when setting the budget cuts at 2.9%, we've taken account of those.
Yeah.
We won't have a direct role in any discussions about how the 2.9% cuts are delivered, but what we will see is what the impacts are when that information is returned, and there'll be an opportunity to review that.
Yeah, no, because the reason why I asked it is that the prison service themselves were very specific that there would be an impact if the cuts proceeded at 5 or 10% of that sort of work with prisoners, which the probation service plays a big role in. So you're just making sure that, now that that's accepted, it would take an impact, that it isn't left to one body to decide how the relationship between them or probation. That's the point. I'm just wondering what role the department would have. So thank you very much.
Any other members? Patsy, sorry, Raymond.
Can I just ask one question? Sorry, Patsy. The £30 million from the Fresh Start in relation to legacy, does the department have a figure of what legacy is currently costing them?
As part of the 16-17 exercise, the department bid for 8.1 million of costs for various DOJ bodies, but in addition, the PSNI we're working on what the cost may be. So we don't have a final estimate at this point in time. The department will bid to that 30 million.
Yeah. But can we maybe perhaps at the next update just be given what it costs each year for legacy, in terms of the department and the police, so as we get an understanding that there's £30 million there.
Yes.
If agreement can be made, and then it might sort of focus minds in terms of ensuring agreement, because obviously that would be a wider saving for the department.
Yes, we'll come back with an update.
Yeah, thank you.
Patsy?
Yeah, thanks, Chair. The document that you supplied to us earlier refers to the 3.9, and you in fact spoke to it there, Mr. Capper, the 3.9 million allocation to the flagship project, NI Community Safety Training College, including the projected spend to 2021. Can you expand as to what that means there, and what is the projected spend to 2021?
Yes, as part of the budget, the executive has agreed a number of flagship projects, where it is not just agreeing funding for 2016-17, but funding over a 5-year period, and Desert Creek appears as one of those projects. And if I am able to find the right page, the draft budget document has a run of figures totalling £79 million over those 5 years for Desert Creek.
79 million over those years for Desert Creek,
Yeah.
and that 3.9 million is part of that 79 million.
That's the 16-17 amount that forms part of that.
All right, and what is that due to go towards? Do you know?
There is a business case that is being prepared for the Northern Ireland Community Safety College. That has been signed off by the accounting officers of the services and is due to go to the executive for consideration.
I know that, but the 3.9 million, what's it for?
3.9 million, the run of figures are based on an estimate of what investment would be required. So the 3.9 million given us the
If
first
you don't
year.
have it today, we can get it,
Well, I can certainly come back with detail of what the 3.9 million is for, but given the stage of the project, it'll be for early design, procurement costs, that sort of thing.
Groundhog Day again. Back to where we were.
Well, I
But I
suppose...
hope on this occasion it's realised. So, given that 3.9 million is, I suppose, small beans compared to what has been spent on it so far. But do you feel sure that it's going to happen, or something's going to happen this time?
I think what I'm able to say is that the executive's budget has identified Desert Creek as a flagship project. It earmarks funding for it, and the executive's due to consider the business case.
So you don't know at this stage whether it's going to happen or not?
I don't think, well, as I've said, what I do know is that the executive's budget has earmarked funding for it. I don't think it would be appropriate for me to
No, I'm not
and
trying to
second
put you on the
guess.
spot, I'm just trying to look a wee bit of clarity for the people. At what point will it be known that something is going to happen on the site other than more design work or business cases?
I think the trigger will be the executive's consideration of the business case.
Which is there a projected time frame for that, or what do we know?
The business case is currently being considered by the Department of Health, and then it will go to the executive.
For ratification or amendment?
I'm not sure what the exact term will be, but I think it will go to the executive for consideration.
Right. So we don't have a time frame really yet for it?
I don't have a timetable of when the business case will go to the executive.
No, I mean I'm looking about actual projected stuff happening on the ground. There's an awful lot, you can appreciate my flavour in this, but you can appreciate there's a whole lot of scepticism around this project, justifiably so, from day dot, whenever people were fired up with enthusiasm and idealism locally and further afield about it. So it's just, I think, if there were to be some sort of tangible, methodical way of working through this, do we see realisation of something rather than notional figures about the place and nothing really happening? So if we had some sort of an idea as to when the executive is likely to sign off on it, and then the projected various stages of the scheme and when those are likely to be signed off, that would be very helpful if the department would provide those to us at some stage, Chair.
Sure.
Okay, thank you.
Okay, anyone else? Okay, thank you all very much.
Thank you.
Okay, members, move on then to agenda item 5, which is the amendments to the firearms legislation. So we're going to have the officials outline the final proposals for amendments to firearms legislation that the department intends to include in this bill, and the responses that's received from key stakeholders. So members will find the relevant papers at page 196 of their meeting folder. So Anthony Harbison, Robert Kidd, both very welcome. If you want to outline where we're at the moment, and then we'll most likely turn over to Patsy for
Only here they too, so it'll just be all me. Can I have the other two's time then?
You want to skip the opening address and then just go through the questions?
Let's go straight. Well, that's what, what are they moving on?
Well, thank you for the opportunity to give the committee an update on the firearms amendments. Normally Simon Rogers would represent the department on this issue, but due to family bereavement, he's unable to be here today. When Simon and Robert were last before the committee on the 26th of November, you suggested that it would be best if they met directly with Messrs Froome, McGlone and Pouts, who had been the committee members most involved in this issue. That meeting took place on the 1st of December, and I'd like to take this opportunity to thank the committee members for their time and their contribution to what I believe was a very helpful discussion. The meeting covered quite a lot of detail and went through the amendments thoroughly, with Simon and Robert explaining the intent of each, and they sought to tie them back to the commitments given by the Minister before the summer. They also responded to a point made at the committee meeting on the 26th of November by agreeing to a single fee for a renewal of a firearms club, which wanted to be authorised as a shotgun club used by young people. I believe that the number of sites offering both target range and clay target facilities to be small in any case. However, the fee schedule takes this into account. The department, when consulting those who had previously engaged on the proposals, asked each consultee would they like to make further comments on the amendments. A small number had views, and they are set out in our response, which the committee has before it today. I should therefore also like to thank those stakeholders who did respond to the consultation on the draft clauses. Their comments were very helpful, and they did enable us to clarify a number of points. As you can see, there was some comment about the new clubs, but I would point out that the Ulster Clay Pigeon Shooting Association have indicated that they are content. Again, the issue of age, which has been discussed with you before, was also raised. We indicated in the past a number of groups accepted the Minister's proposal as an appropriate way forward, but 3 organisations in particular still do not agree. In light of this, the Minister has once again considered the matter and has concluded that his approach is the correct, proportionate one, bearing in mind public safety. His proposals would see a significant relaxation in the existing rules so as to enable clay target shooting by 12 to 15-year-olds in PSNI authorised clubs, coupled with greater access at 16 onwards to shotguns, on top of existing options for young people to shoot, e.g. to shoot more in a more appropriate and controlled club. The bill will also enable future changes, if appropriate, by affirmative regulation. One additional issue I would bring to the attention of the committee relates to the intention of the repeal on Unlawful Drilling Act and its reference to the Firearms NI Northern Ireland Order 2004. The repeal of the Unlawful Drilling Act of 1819 would require the consent of the Secretary of State for Northern Ireland, and we believe would need to be examined in slower time. Although the Secretary of State's consent could be sought, we would need to fully understand the implications of such a repeal. This would require appropriate consultation, which in turn requires discussion about who could lead that consultation. In the meantime, we can confirm there has been no prosecutions under this Act since 2006, and we would want to understand both the PPS and the PSNI's views once we sort out who can actually lead on the issue. Given the timescale for the Justice No. 2 Bill provisions, and the fact that there have been no prosecutions for quite some considerable time, we therefore feel that it would be prudent to take this forward as a separate issue in slower time. Aside from the issues highlighted, we believe that there is broad agreement on the way ahead, and I would therefore ask the committee to endorse the proposals. We are, of course, happy to take any comments or questions that you may have.
Okay, thank you very much. Patsy.
Thanks very much, Chair. Just if I could work my way through this, there are a few items just of clarity that are required. In regard to the stakeholders that accepted the amendments, who were those? Just a wee bit of side information.
The Northern Ireland Firearms Dealers Association, the Ulster Clay Pigeon Shooting Association, and the Scottish Association for Country Sports.
All right, thank you. Just as I work my way through the document, one of the issues was that people, in terms of the certificate, wanted it amended to allow more space on the actual certificate itself, because there may be... Now, it was said that that's an administrative matter. Is that a major issue to be done? It seems to me just like changing form to allow more space on it or to put more lanes on it.
If I can answer that one. We've passed this to the PSNI, obviously, for their consideration. Clearly, it's not something which would be on the face of the bill. It is purely an administrative matter. One of the things we've asked them to look at is possibly a continuation sheet,
Yes.
or more boxes on the sheet.
All right, there aren't any crazy things going to come up like copyright matters or anything like that. This is purely their own.
It's a
Yes,
PSNI
it's
form.
just their
All right,
own,
it's just a
and
form.
then
That's okay. That's grand. There was a matter referred to here about the guidance to be issued along with it. Have those guidance been drafted yet, or any guidance been drafted yet?
We need to finalise the clauses
All
before
right,
we can start
that's
on
okay.
the guidance.
That's grand. Now, there was, and we raised this with you previously, Robert, and I'm not too sure where this fits in, but with the likes of, say, someone who has purely rimfire, duty rimfire, the capacity for a semi-automatic rimfire to say, Ruger 1022, very popular wee gun, for that to be switched under the banding system for, say, bolt action. Does this, that's for sporting, not for target purposes, within the banding system, does this make provision for that to happen?
Yes.
Purely for the rimfires?
Under the banded system, if the calibers are listed in the banded system, the type of action can change. So,
All right. That's okay. There was something, and I'm kind of surprised at this. Yes, the shotgun clubs, as you conceive them to be, will they be required to have or to hold club guns for the purpose of this?
no, they will not be required. The current existing system, whereby a shotgun club
Yes.
has an opportunity to voluntarily register with PSNI, will continue to exist. The only thing we're introducing is a registration scheme for those clubs which wish to open their doors to 12 to 15-year-olds.
Right.
If a shotgun club wishes to make arrangements to hold club guns as a centre fire
Yes.
or other target club, that will be entirely a matter for them with the PSNI.
Right. Now, around the authorisation issue, and you mentioned the PSNI there, Article 49 of the Guidance on Firearms Controls, would that be then form, or could it form part of a condition of the authorisation?
Article 49 for firearms clubs. We have effectively
Because
merged
it's guidance.
Article 49 of the order itself, the actual
Yes.
order as opposed to the guidance.
Of the guidance, Article 49 of the guidance.
Oh, sorry, when we come to the guidance, yes, it will be broadly similar.
But that still has to be...
We still haven't worked our way through
we
the
haven't.
guidance at this point in time, so
That's grand,
that
that's
needs to be
grand.
handled. Yeah.
Sorry, if I can just clarify that for yourself, Mr. McGlone.
Yes.
The clauses which are included, the new 50A,
Yes.
will mirror broadly 49.4 of the 2004 order,
Okay.
with the exception of the reference to the Unlawful Drilling Act.
Right, okay, right. Now, this is one point that I picked up on myself, and I'm not too sure just about it, and that is the whole issue. Say, for example, we'll deal with this where an underage, as it's referred to at 12, and the whole intention of that. I'm surprised that the Ulster Clay Pigeon people didn't pick up on this. And I'm not quite sure that the legislation as drafted here would allow for this. The whole idea and the whole purpose of that is to bring on young shoots to perform at high level, Olympic level, national level, international level. That's the whole purpose of it. But the legislation as is drafted here, it refers to a person who has held a firearms certificate for a shotgun for at least 5 years. Now, many of these coaches, as you know, will be coming, including from GB, or they could be coming from the Republic. Does that description there, because a person who's coming from GB will have a shotgun, obviously, if they're a top coach, but they will not, or they may not have a firearms certificate, because, as you know, the difference between firearms certificate and shotgun certificate, you can have a shotgun certificate in GB, but you don't necessarily need to have a firearms certificate. And that, as I read it, it says here, has held a firearms certificate for a shotgun for at least 5 years. You could conceivably have a top coach coming from England, Scotland, Wales, or wherever, or even a top player or a top shot, who would not have had or ever had a firearms certificate or no intention of it, but has clearly a shotgun certificate. So I'm just thinking of that possibility where someone interpreting that, not in the spirit of how it's meant, could exclude or make it difficult for that type of situation to arise.
We can certainly clarify that with the draftsman, Mr. McGlone.
Could you?
My understanding is our wording is a firearms certificate for a shotgun, so we would anticipate that that would include a shotgun certificate.
But you can understand
Yeah, I see
in
where you're coming
GB
from.
where it wouldn't be a firearms certificate, it would be a shotgun certificate.
It's a nomenclature issue.
Yes, aye.
We'll clarify that going forward, but it certainly wasn't the intent of the clause.
No, it wasn't.
We will clarify.
But it could arise that you could have a very good situation for a young shot and a person standing there who's a top shot,
Yes.
but not able to mentor that young person. And just on that, does the person who is, if you like, mentoring have to own the shotgun?
No, again, sorry, just to clarify, I suppose there are a number of different descriptions here. The individual who actually owns the shotgun may or may not be the supervisor.
All right, okay.
So you could have a young person being coached, as you rightly say, by someone from England.
Yes.
His father is there with him, who is effectively the supervisor and the owner of the shotgun. So you could have different scenarios.
Okay, right. That's grand. Let me see now. And the issue there, it's at part 2. Let's see now. Paragraph it's 4B1. The second firearm is the same type and calibre as the firearm. That's not going to back to the semi-automatic rimfire and all that. That's not going to add complications there. Type and calibre.
That's outside of the banded system.
That's outside of the banded system, right? But it's not going to confuse matters for anybody, no? Right, that's okay. Okay. That's grand. I think maybe we've covered it all fairly well there. But you'll be able to pick up on those couple of 3 issues and get back to us, including the guidelines then.
Well, the guidelines will come once the clauses are
Right. Oh, no, that's grand. That's okay.
redeveloped.
That's okay. Chair, thanks very much indeed. And thank you for your time.
Anyone else have any questions? No? Okay, thank you very much. Thank you.
Yep.
Okay, members. Can I ask, are we content to support the proposed amendments to the firearms legislation that the Department intends to bring forward at consideration stage? Great. Okay. We'll go on to that in the formal clause by clause, and we'll address the issue again then. Agenda item 6 is the consideration of proposed amendments by Lord Morrow and Basil McCrae. The relevant papers have been circulated by email yesterday and are at pages 18 to 89 of the tabled pack. And a copy of the draft text of Basil McCrae's proposed amendments were received late yesterday and are found at pages 90 to 94 of the table pack as well. Lord Morrow hasn't provided the final text of his proposed amendment, which makes it slightly more difficult for us, but a response from the Department of Health on both Lord Morrow's proposed amendment and the proposal that Mr Poots had made around on-the-spot fines has been received today from the Health Minister, and there's copies of that have been tabled in front of you as well. They have, the Minister's expressed some concern over both, but they're laid out in detail in the letter if people want to have a read through that. Just to remind the committee, Mr McCrae is proposing amendments to regulate the flying of flags and lampposts, and the views of the Department of Justice and PSNI are included in the papers as well. The Department doesn't believe that the Justice No. 2 Bill is an appropriate legislative framework to bring the measures forward. It's highlighted that flying of flags across the departmental issue with OFM, DFM, social development, regional development and DOE, local councillors and other statutory authorities all playing a part, and it's of the view that the most suitable way forward is through the Commission on Flags, Identity, Culture and Tradition, established by March of this year, as was set out in the Stormont House Agreement and reaffirmed in the Fresh Start document. The PSNI acknowledges the need for a resolution of the flags issue and would support any legislation that could provide a solution. It has, however, pointed out that it's a very complex issue which is difficult to comment on in depth without seeing detailed amendments, and suggested it would be appropriate to wait for the publication of research on this issue by Dr Nolan and Professor Bryan, which is due in early 2016. Now, we had an opportunity to meet with Mr McCrae on his amendments. I'm not sure that anybody was particularly enthused by the proposal. I think we commended what he was trying to do, but I just don't think that the way that he was going about it would actually achieve the desired outcome. But I'll throw it up to the members to seek views on Mr McCrae's amendments.
We would see the Commission as the basis to explore this issue rather than trying to deal with it through this group.
Yeah. If members are generally agreed with that view, we can reflect that in report. I think that's probably the most sensible way forward on it. Then, just to remind the committee, Lord Morrow is proposing an amendment to Section 66(1) of the Police Act, which currently relates to assaults on members of the police service, so that it specifically covers assaults and or attacks on members of the emergency services, the police, fire and ambulance service staff, so they're protected by the law to the same extent as a police officer. During the oral evidence session with Lord Morrow, discussions took place regarding the potential for the proposed amendment to also cover a range of other staff, including frontline medical staff in accident emergency departments, nursing staff and social workers undertaking home visits, and voluntary organisations such as the Lagan Search and Rescue that we visited earlier, towards the end of last year. During the oral evidence session, as I mentioned earlier, it was the 3rd of December, Mr Poots had raised the issue of on-the-spot fines in hospitals for less violent low-level behaviour, such as verbal abuse or a push, and asked what potential there is for amendments to this bill to have a fixed penalty notice imposed upon people at the time of the incident and administered in hospitals or by emergency services to support people providing frontline services from being abused by individuals to take them in those areas. The views of the Department and the PPS are included in the papers. The Department's highlighted that assaults upon fire and rescue personnel are already covered under Article 57 of the Fire and Rescue Services Order. which provides that any person who assaults or obstructs a fire and rescue officer or a person assisting commits an offence and assaults upon other public servants, including paramedics, can be prosecuted under existing legislation. Attacks on public servants or which damages emergency equipment may already be treated as aggregating factors when sentencing occurs. The Department has indicated that the issues may be complex and they engage the interests of the Department of Health. It's raised the matter with health officials and intends to meet with them to discuss the matter in further detail when they've had an opportunity to consider the issues. The PPS has commented on the practical implications of Lord Morrow's amendment and has highlighted the complexities with the existing legislation which would transfer if applied to the emergency services. The PPS has also confirmed that where the victim is someone who is serving the public, prosecutors are advised to consider this as an aggregating factor in making prosecution decisions. Sentencing guidelines for the Magistrates Court and aggregating factors also cover the situation where the victim was engaged in providing a service to the public and includes a wide range of occupations, including emergency services personnel, doctors, nurses and other hospital staff. In relation to legislating for on-the-spot fines for less violent behaviour in hospital premises, DOJ is discussing in detail with health officials. The Department's initial view was that the use of fixed penalties in Northern Ireland is currently restricted to a range of low-level non-violent offences, and fixed penalties are not appropriate in circumstances where the use of or threat of violence is a factor. It also believes that where behaviour amounts to the commission of a criminal offence, this should be a matter of consideration for PPS. In that letter that we've tabled today, the Health Minister has indicated that there will be a reluctance of staff and any to actually have that power, which is one of the issues that I'd raised previously as well, whether nursing staff would actually want to have that power. It's almost a quasi-judicial role for them. And he has outlined that in his letter that's been sent to us today. So members, I suppose the difficulty in us taking a view on Lord Morrow's amendment, given that we don't have the text of the amendment, makes it virtually impossible for us to do. So if members are content, I would suggest that perhaps we reflect in our report that we had an evidence session from Lord Morrow, that we were broadly sympathetic with what he was trying to do. That is the view of the committee, but we recognise that there may be some difficulties with it. There may be existing legislation, and reflect the information that's been given to us by the Department, PPS and the Health Minister. If members are content with that approach? Yeah. And we'll obviously do the same with the Edwin Pooch proposals, because again I think people were broadly sympathetic with what he's trying to do, although we've identified difficulties with it. Yeah, and we'll reflect on the report as well. Okay then, move on to agenda item 7, is the consideration of proposed committee amendments. We will consider the 2 draft amendments that we requested be prepared at the meeting back on the 10th of December as well. Relevant papers are page 283 to 350. So if members are content, we'll move into closed session to do that. Happy enough? Yeah. Okay.
This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.
Agenda item 8 then. It's just to keep everybody in their gallery on their toes. They'll have to come in and out again. The committee will now consider the proposed legislative changes to improve online protection for children that were suggested by Jim Gamble when he attended the meeting on the 5th of November, and that followed the conference that we held in W5 Justice and Digital Age. Relevant papers, page 352 of your meeting folders. Now, 3 areas that he had made suggestions. The first one was an amendment to the current law, so the child or young person under the age of 18 who takes, makes, distributes or possesses an image of themselves will commit no criminal offence unless it's done with malicious intent. The second was the amendment to the existing law for the creation of a new law to deal with the aggravated impact when an individual uses the anonymity provided by the internet and or the ability to create multiple online accounts with the intent to harass another person. And the third one was the creation of a new law relating to circumstances where a person of 18 or over masquerades as a person below that age and engages online with an individual they know or believe to be under the age of 18. A summary of the views of the Department, the PSNI, the Public Prosecution Service and the Human Rights Commission on each of the proposals, together with the Assembly research paper that we had commissioned, is included in the papers. The responses, whilst supportive of some of the proposals in principle, state that these are complex areas of law and highlight a range of issues that would need to be taken into account if amendments were to be made to the Justice No. 2 Bill to ensure there was no unintended consequences. The Minister is concerned that bringing forward amendments at this stage will result in changes being made to this important area of law without the benefit of proper policy consideration and consultation. He's therefore asked the Committee to support the inclusion of the proposals in a policy consultation for future legislative change as part of a wider review into a number of related areas covering certain sexual offences and child protection, rather than pursuing them as part of the Justice No. 2 Bill. To demonstrate that this work is being progressed, the Ministry aims to brief the Committee more fully on their policy consultation in the early part of this year. So, members, we then have to decide whether we want to push ahead with any proposals or are we content to allow the Minister to go out and consult on it. I think that the point that we wanted to make is that we wanted to have some value from our conference and have an outcome from it. And I think we were sympathetic with what Mr Gamble was proposing, although given that we have spoken to a number of people who would be dealing with the legislation, they're looking at some concerns. It may be more prudent to allow the Minister to go out and consult on it, if members are generally content with that. What I would add is that we want to see this done pretty quickly. It's not one of those things that we will consult on it and 6 months, 10 months down the line, nothing's happened. So if members are content, then we'll say to the Minister we're content to allow them to go out and consult, but we do want to see that happening pretty quickly.
Agreed.
Members happy enough?
Agreed.
Yeah. Okay. Well then, members, we're going to have to go back to agenda item 7, which means we're going back into closed session again, if everyone's content. I guess she is now. Okay, so we'll move back into closed session for...
This is the Northern Ireland Assembly.
Okay, are we content then for the committee to table the amendment that provides for the enabling clause that will allow the department to provide the court with powers to require offenders to satisfy a fine by undertaking appropriate courses to address offending behaviour such as drug or alcohol treatment courses as an alternative to supervised activity orders in due course when suitable arrangements are in place at a consideration stage? Happy enough? And we're content for the committee to table the amendment which creates a new offence of disclosing private sexual photographs and films with intent to cause distress, otherwise known as revenge porn, at consideration stage of the bill as well. Agreed. Yep. Okay, thank you very much, members. We'll move on then to agenda item 9, which is our formal clause-by-clause consideration. This is where it could go wrong. Work our way through this as methodically as we can. So, undertaking our formal clause-by-clause, just number 2 bill and proposed amendments. For ease of reference, a paper setting out the committee's deliberations and the text of the proposed amendments to the bill, including 2 further amendments to Part 2 of the bill, provided by the Department in response to the committee's deliberations, and which provide the prison ombudsman with the power to commence investigations on his own volition and place a duty in the Justice Minister to request the ombudsman to conduct investigations in cases of near death. Were circulated electronically to members yesterday and have been included in the pack at pages 95 to 146 of the tabled papers. So we'll proceed through the clauses and schedules of the bill in order and put the questions formally. There are amendments that were put to the question on the amendment first. There's no amendments have been proposed and no issues have been highlighted. I'll seek the agreement of the committee to group these particular clauses when putting the question. I just ask that members are loud with their agreement or disagreement. Sometimes these things, members lose the will after a few of them, so please do make their views known. So if we deal with Part 1 first, collection and enforcement of financial penalties, the Department has provided the text of 5 substantive amendments and a number of minor and technical amendments to this part of the bill, and during the discussions members indicated that they were broadly content with the provisions and the proposed amendments. So new clauses 9A, 9B and 9C. I'll put the question, is the committee content with the proposed departmental amendments to introduce new clauses 9A, 9B, 9C to provide for police power of arrest in circumstances of non-attendance at fine default hearings? Agreed? Yep. Okay, new clause 9D. I'll put the question, is the committee content with the proposed departmental amendment to create a power for the recovery of the fee for the cost of default hearings? Agreed? New clause 12A. Is the committee content with the proposed departmental amendment to introduce new clause 12A to improve information access and sharing by collection officers? Agreed? Yep. Yep. Okay. Clause 1. Is the committee content with the proposed departmental amendment to clause 1, which is a consequence of the introduction of clause 12A relating to information access and sharing by collection officers? Agreed? Is the committee content with clause 1 subject to the departmental amendment? Agreed? Yep. Okay, then clause 2. Is the committee content with clause 2 as drafted? Agreed? Yep. Okay, clause 3. Is the committee content with clause 3 as drafted? Content? Yep. Yep. Okay then, clause 4. Is the committee content with the proposed departmental minor drafting amendments to clause 4? Content? Yep. Is the committee content with clause 4 subject to the departmental amendments? Content? Okay, move on to clause 5 then. Is the committee content with the proposed departmental technical amendment to clause 5? Yeah. And is the committee content with clause 5 subject to the departmental amendment? Yeah. Agreed? Yeah. Move on to clause 6. Is the committee content with the proposed departmental amendment to clause 6 regarding making a vehicle seizure order only if satisfied that the value of the vehicle, if sold, would discharge the sum owed, including the likely charges and costs of a sale and minor drafting amendment?
Which clause that?
Clause 6.
6, okay.
Okay, happy enough?
Yep.
And then, is the committee content with clause 6, subject to the departmental amendments? Yeah. Agreed?
Yeah.
Okay, move on then to clause 7. Is the committee content with the proposed departmental amendment to clause 7, which is a consequence of the introduction of new clauses to provide for police power of arrest in circumstances of non-attendance and fine default hearings?
Yeah.
Yep. Is the committee content with clause 7, subject to the departmental amendment? Yep. Okay, clause 8. Is the committee content with clause 8 as drafted? Yep. Okay, clause 9 then. Is the committee content with the proposed departmental amendment to clause 9 relating to the introduction of the police power of arrest in circumstances of non-attendance and fine default hearings?
Yeah.
Yeah. And then we need to... So is the committee content with the proposed amendment to clause 9, which is the enabling power for the drug and alcohol rehabilitation that we've just discussed? Yep. Okay. Is the committee content with clause 9, subject to the departmental and committee amendment? Okay. Move on then to clause 10. Is the committee content with clause 10 as drafted?
Chair, just in relation to these type of clauses, clause 11 provides for regulation, and we would be seeking from the Minister, obviously in terms of taking money from benefits and the wider impact, but that would be, we have reservations until we hear Minister make a commitment on the floor.
Okay, that's okay. Did we get clause 10 agreed, did we?
Yeah, it's just saying the application.
No, I understand.
Contingent, yeah,
Understand,
contingent
that's fine.
on.
Okay. Well, I'll do clause it. Committee content with clause 10 is drafted. Agreed.
Yeah.
No opposition to the such. Then we'll move on to clause 11 then, and we'll reflect some of that in the report as well. Is the committee content with the proposed departmental amendment to clause 11 that provides for the regulations to make further provision about applications for deductions from benefits?
Yeah, just that sort of wider consideration, yeah.
Okay, great. Is the committee content then with clause 11 subject to the departmental amendment? Yeah.
Yeah.
Clause 12 then. Is the committee content with clause 12 as drafted? Great. Clause 13. Is the committee content with the proposed departmental minor drafting amendment to clause 13? We agreed?
Yeah.
Is the committee content with clause 13 subject to that departmental amendment? Yeah. Agreed? Okay, clause 14. Is the committee content with clause 14 as drafted? Yeah. Clause 15. Is the committee content with clause 15 as drafted?
Again, 15 would be one of those ones where we would be seeking just a commitment from the Minister that it wouldn't impact negatively on a family.
Okay. Okay then. Clause 16. Is the committee content with clause 16 as drafted?
Yeah.
Yep. Clause 17. Is the committee content with clause 17 as drafted? Yep. Clause 18. Is the committee content with the proposed departmental amendments to clause 18 relating to the introduction of the police power of arrest in circumstances of non-attendance at fine default hearings and to specify the issues that the court should take into account before making a vehicle seizure order? Yeah. Okay, then is the committee content with clause 18 subject to the departmental amendments? Yep.
Yeah, again, just a bit wider consideration about impact.
Okay. Clauses 19 to 21. Can we get the agreement then of the committee to group clauses 19 to 21 for the purposes of putting the question?
Yep.
Yeah. Okay, then is the committee content with clauses 19 to 21 as drafted?
Yeah.
Okay. Clause 22 then, is the committee content with the proposed departmental amendment, which is a consequence of the introduction of the new clause relating to information access and sharing by collection officers?
Yep.
Is the committee content with clause 22 subject to the departmental amendment? Clause 23 then. An amendment to clause 23 relates to part 4 of the bill, and therefore I intend to put the question in this clause at that stage, if members are content then. So we'll move on to clause 24. Is the committee content with the proposed departmental amendment to clause 24 to ensure that a supervised activity order cannot be considered as an option in default of a confiscation order and the minor drafting amendments? Yeah. And is the committee content with clause 24 subject to the departmental amendments? Clause 25, is the committee content with the proposed departmental minor technical amendment to clause 25? Is the committee content with clause 25 subject to the departmental amendment? Clause 26 then, is the committee content with clause 26 as drafted? Clause 27, is the committee content with the proposed departmental minor amendment to clause 27 to correct a date? Okay, is the committee content with clause 27 subject to the departmental amendment? Yep. Okay then, Schedule 1, is the committee content with the proposed departmental minor drafting amendments to Schedule 1?
Yeah.
Is the committee content with Schedule 1 subject to the departmental amendments?
Yeah.
Schedule 2 then, is the committee content with the proposed departmental amendments to Schedule 2 to ensure that a warrant of committal for default under the bill is treated the same as a similar warrant under the Magistrates Court Order 1981, and prosecutorial fines can be treated in the same way as the fixed penalties and penalty notices already included in Schedule 2 and the minor drafting amendment. And then is the committee content with Schedule 2 subject to the departmental amendments? Okay. Move on then to Part 2 of the bill, the Prisoner Ombudsman. The Department's provided the text of 5 substantive amendments and several minor drafting amendments to this part of the bill. During the discussions, members indicated they were generally content with the provisions and the proposed amendments, although one member highlighted some reservations regarding Clause 38. So if we work our way through this then, starting with Clause 28, is the committee content with Clause 28 as drafted?
Yep.
Okay then, new clauses 35A and 35B. Is the committee content with the proposed departmental amendments to introduce new clauses 35A and 35B to enable the prison ombudsman to initiate investigations on his own volition?
Yep.
Clause 29 then. Is the committee content with the proposed departmental amendment to clause 29 as a consequence of new clauses 35A and 35B?
Yep.
Is the committee content with clause 29 subject to the departmental amendment?
Yep.
Good. 30. Is the committee content with the proposed departmental amendments to clause 30 to create a power to defer investigations where ombudsman considers it necessary to do so, and to require the ombudsman to inform the police of a suspected criminal offence as part of any investigation he is conducting? Yep.
Yep.
Is the committee content with clause 30 subject to departmental amendments?
Yep.
Yep. Clause 31 then. Is the committee content with clause 31 as drafted? And 32, is the committee content with the proposed departmental amendment to clause 32 to create a power to defer investigations where the ombudsman considers it necessary to do so? Is the committee content with clause 32 subject to the departmental amendment?
Yep.
33 then, is the committee content with clause 33 as drafted?
Yep.
34, is the committee content with the proposed departmental amendments to clause 34 to require the ombudsman to inform the police of a suspected criminal offence as part of any investigation he's conducting, and to place a duty on the Minister of Justice to request the Ombudsman to conduct an investigation in cases of near death?
Yeah.
Is the committee content with clause 34 subject to the departmental amendments?
Yeah.
Okay, clause 35, is the committee content with clause 35 as drafted? Yep. 36, is the committee content with 36 as drafted?
We would maybe possibly seek to amend that around compelling witnesses, but in terms of what's on the face of the bill, we agree.
Sure. Okay. Clause 37 then, is the committee content with the proposed departmental amendments to clause 37 to change the reference to the Northern Ireland Public Services Ombudsman to Ombudsman, and to add the Attorney General to the list of bodies to which protected information may be disclosed?
Okay.
Okay then, is the committee content with clause 37 subject to the proposed departmental amendments? Move on to 38, is the committee content with clause 38 as drafted?
No, we will be opposing 38.
Do you want to have a vote now in committee?
Oh, no, we'll just, no, it's okay.
Okay, just the party. Okay.
Stay our opposite.
No problem. Okay, great then. Clause 39, is the committee content with clause 39 as drafted? Yeah. Clause 40, is the committee content with the proposed departmental amendment to clause 40, which is consequential to new clause 35A? Agreed? Yep.
Yeah.
Is the committee content with clause 40, subject to the departmental amendment?
Yeah.
Okay, Schedule 3, is the committee content with the proposed departmental amendments to Schedule 3? Change the references to the Northern Ireland Public Services Ombudsman to Ombudsman? Sorry, Ombudsperson to Ombudsman? Yep. Okay. Is the committee content with Schedule 3, subject to the departmental amendments?
Chair?
Yep.
In relation to Schedule 3,
Yep.
where it is written on the face of the bill that a person convicted of a criminal offence would no longer be the prisoner ombudsman. We agree with the NIACRO position. It should be an assessment and the relevance of the offence and ability to carry out the job.
Okay then, move on to part 3, miscellaneous. During discussions, the committee indicated it was content with clauses 41 through to 44, and there are no proposed amendments. So, can I get the agreement of the committee then to group clauses 41 to 44
Yeah.
for the purpose of putting the question? Okay. Is the committee content with clauses 41 to 44 as drafted?
Yep. Yeah.
Okay, I'll now put the questions on the Department of Agriculture and Rural Development Amendment to the Welfare of Animals Act 2011 and the DOJ amendments relating to direct committal for trial of the Courts Fund Office. During discussions, members indicated they were content to support the amendments. Is the committee content with the proposed Department of Agriculture and Rural Development Amendment that introduces a new clause 40A to increase penalties for animal welfare offences in Animal Welfare Act 2011? Yep. Is the committee content with the proposed departmental amendment to introduce a new clause 44A to provide the required authority to introduce a fee structure for the Court Funds Office to deliver full cost recovery? Yep.
Yep.
Is the committee content with the proposed departmental amendment to introduce a new clause after clause 44 relating to the direct committal for trial provisions in section 9 of the Justice Act 2015? Yep. Okay, I'll now put the question on the firearms amendments that was considered earlier. Is the committee content with the proposed departmental amendments to introduce new clauses after clause 44 to amend the Firearms No Land Order 2004 and Unlawful Drilling Act 1819 and introduce a new schedule covering the authorisation of shotgun clubs to allow use of shotguns by minors for limited purposes, variation of firearms certificates and fees?
Chair, that may be subject to a slight wording variation on one part of it. And point that raised there about the pigeon shooting, you know, and the jurisdictions from which those certificate holders come from.
Yeah.
To allow for that.
If you're happy enough, we'll note that.
Right, subject to whatever they respond with.
That's fine. Okay.
To accommodate that.
Okay. And then, are we content with the committee amendment then on that we discussed earlier? The revenge porn.
Yep.
Legalistic term that, but we all know what we're talking about. Yeah. Okay. Part 4 then. The Department advised the committee of its proposal to remove clause 45 from the bill in its entirety and replace it with a power to make ancillary provisions under more restrictive circumstances limited to Part 1 of the bill.
Yeah.
It subsequently provided the text of an amendment to clause 23, and during discussions the committee indicated it was content with this approach and the rest of the clauses in Part 4. So clause 45 then, is the committee content with clause 45 as drafted?
Yeah. Mm-hmm.
No, we're not.
No.
Yeah, we have to remove it.
Withdrawn.
Yeah.
All right,
So we'll do that again. Is the committee content with clause 45 of the bill as drafted? No?
No.
I agree with
Okay,
that.
good. And then clause 23 then, given that we have opposed clause 45, is the committee content with the proposed departmental amendment to clause 23 to provide a power to make ancillary provisions to Part 1 of the bill?
Yeah.
We are, this one?
Yeah.
Yes.
Yep.
Okay. And is the committee content with clause 23 subject to the departmental amendment?
Yes.
Yep. Okay. Clause 46 then, is the committee content with the proposed departmental amendments to clause 46, which are consequential to the removal of clause 45 and the amendment to clause 23, and as a result of the amendment to clause 34 to place a duty on the Minister of Justice to request the Ombudsman to conduct an investigation in cases of near death? Yep.
Yeah.
Okay. Is the committee content with clause 46 subject to the proposed departmental amendments? Yep.
Yeah.
Clause 47 then, is the committee content with the proposed departmental amendments to clause 47, which are consequential to the amendment to clause 23 and the amendments relating to penalties for animal welfare offences? Yep. The committee content with clause 47 subject to the departmental amendment? Yep. Okay, long title then. As this is the end of the clause by clause consideration, the committee must now consider the long title of the bill. So is the committee content with the proposed departmental amendments to the long title consequential to the firearms amendments? Is the committee content with the long title of the bill subject to the departmental amendments? Yep.
Yeah.
Okay. Thank you very much. That was relatively painless. The draft report of the bill is being prepared for consideration and approval at our meeting on the 14th of January. So, very quick turnaround. Okay, thanks very much, members. Move on then to agenda item 10. Can I refer you to page 408 of your packs? Proposed rules amend Order 29, Rule 13 of the Rules of the Court of Judicature, 1980, to enable the High Court to order the making of interim payments in personal injury cases involving 2 or more defendants. Currently, the 1980 rules allow the Court to order interim compensation payments in personal injury cases involving 1 defendant. However, where there are multiple defendants disputing liability, the power of the Court to order interim payments is inhibited by a requirement that the Court be satisfied that the case will succeed against the particular defendant making payment. This is procedural anomaly and has been brought into sharp relief in an ongoing case involving a baby suffering injuries described as catastrophic as a result of a road traffic collision.
Yeah.
Given the situation in the Court of Judicial Rules Committee brought forward amending rules as a matter of urgency which allow the Court to order interim payments in personal injury cases involving multiple defendants subject to certain specified conditions being satisfied. Due to the circumstances and a departure from usual practice, the Department has proceeded with laying the rules which are subject to the negative resolution procedure in advance of the Committee considering the policy proposal. The rule will come into operation the 6th of January and the relevant statutory period will end on the 9th of February 2016. So are we content then with the policy intention behind the proposed statutory rule?
Yeah.
Yep. Okay. The statutory rule then scheduled for consideration at next week's meeting. Agenda item 11 then, can I refer to page 418. Schedule 13 to the Pensions Act, Northern Ireland 2015, which received Royal Assent on the 23rd of June last year, makes provision for the abolition of contracting out by way of an amendment to the Pension Scheme Act 1993. The 2015 Act modifies the definition of cessation date and specifically introduces a date of the 6th of April 2016 for the abolition of contracting out for salary-related schemes. All public sector schemes, including the police pension scheme, is therefore required to make a minor technical change to introduce a previously deferred consequential amendment for the protection of increases in guaranteed minimum pensions after the abolition of contracting out. The Department is therefore proposing to make a statutory rule an exercise of the powers conferred by Section 24 of the Public Service Pension Act 2014 to make the necessary technical change. At the meeting of the 3rd of December 2015, the Committee considered and agreed that it was content with the proposal for a statutory rule to make the necessary technical change. The draft statutory rule was laid by the Department on the 4th of December and is subject to the draft affirmative resolution procedure. There have been no changes to the policy content since the SL1 was submitted to the Committee, and the Examiner of Statutory Rules has confirmed that he has no issues to raise with regard to the technical aspects of the rule. So if the Committee is content, we'll put the question that the Committee for Justice considered draft statutory rule, police pensions, consequential provisions amendment regulations Northern Ireland 2016 and recommends that it be affirmed by the Assembly. Okay.
Is that the Minister doing that next week, or is that a different provision?
It's 19.
The 19th.
18th, it's this year, is it? Yeah, that's it. He's bringing it to the floor.
It'll be the week after.
Yeah, okay.
Yeah. Yeah. Okay, agenda item 12 then, page 432. The Department's written indicating its intention to conduct a targeted consultation on the draft police pension, additional voluntary contributions regulations. The proposed regulations will amend the RUC pensions regulations 1983 and allow members of this additional voluntary contribution scheme to access flexibilities first announced in Budget 2014 and subsequently included in the Taxation of Pensions Act 2014. Similar legislation is being prepared in Scotland, England and Wales. It's intended that the targeted consultation will run from the 8th of January to the 27th of January. The Police Association, the Northern Ireland Policing Board and the PSNI have indicated their support in principle for the proposals. And following completion of the targeted consultation, the Department intends to bring the proposed regulations to the Committee for consideration in early February. So members happy enough to note the intention to undertake a 2-week consultation. Agenda item 13, page 446. Officials attended the meeting on the 2nd of July to brief the Committee on draft guidance for the Northern Ireland Legal Services Agency to outline the concepts of the prospects for success and cost-benefit tests for applications for civil legal aid and to strengthen the application of the existing merits test by outlining exactly what information the solicitor has to provide at the outset of the case. The Department indicated that the guidance would not reduce the scope of civil legal aid and would in no way fetter the discretion of the Legal Services Agency in determining the granting of legal aid, as each case would continue to be judged on its individual merits. The Department intended to share the draft guidance with the legal profession for comment before it came into operation. The Department has now sought the views of the legal profession in the draft guidance by way of a targeted 4-week consultation with the Law Society and Bar Council. Whilst the Bar Council raised some initial queries which the Department responded to immediately, no substantive comments were subsequently received from either body. The Minister has now approved the draft guidance, which does not require legislative change, and subject to views expressed by the Committee, the Department intends to issue it to the Legal Services Agency, who will issue a circular to the legal profession outlining the revised arrangements. The Department intends to provide a report following the first year of operation of the new procedures and the impact of them, and whether the guidance is operating in the way that they intend. So are we content to note that?
Yeah.
Agenda item 14 then, page 478. Members will recall in the meeting on the 10th of December, we noted correspondence from the Department regarding a European Commission proposal for an amending directive on firearms, a number of areas which could impact upon Northern Ireland, and a targeted consultation the Department intended to carry out with key stakeholders to enable it to submit representations to the Home Office, who is taking the lead in negotiations prior to the date of the 18th of December. The Department has now provided a summary of the responses it received to the targeted consultation and the main issues raised. So again, members, I'm happy to note the responses to that consultation. Okay. 15 then is correspondence. There are 18 items of correspondence from pages 518 to 602. Item 1, page 522, is correspondence from the Department providing a response to the Committee for the Environment and Scrap Metal Dealers Bill, with a particular focus on the number of specific clauses. Just reminding that the Committee for Environment has also written to the Committee seeking the views on the bill. Are we content to note the response from the Department? Okay. Item 12, page 568, is correspondence from the Northern Ireland Assembly EU Affairs Manager in relation to UK participation in the Prüm decisions, which are about the sharing of with other EU countries in strictly controlled circumstances, the DNA profiles, fingerprints and vehicle registration data. If members are content, we'll request information from the Department of Justice on what discussions it's had with the Home Office this matter and any likely implications that there will be for Northern Ireland. Happy enough to do that? Item 18 at page 601. It's the second report from the monitoring of the implementation of Youth Justice Review recommendations. Oral evidence sessions in the report with the Chief Inspector, the Department and key stakeholders have been scheduled for the meetings on the 14th and 28th of January. Again, ask members, are they happy enough to forward a copy of the report to the OFM-DFM Committee as well, given their role with regard to oversight of delivering social change programmes? Happy enough? Yep. Okay, any other items of correspondence members wish to draw their attention? Okay, and we'll action the correspondence as outlined in the meeting folder. Move on to agenda item 16. There's no chairman's business. Agenda item 17, AOB. Any members, any issues to raise? If not, agenda 18, date, time, place, the next meeting, 14th of January, 2 p.m.